much, and thank you all for joining, and thank you to ChIPs for giving us this opportunity. I'm Barath. I'm counsel at Debevoise, helping lead their technology litigation group. Was a partner at Kirkland before this and have been doing trade secret litigation for the last approaching 15 years. And I'm joined now with Emily O'Brien at the end. She is managing counsel in litigation at Google. She manages complex IP cases throughout the world with a particular focus on advertising, which I just learned recently. Then to her right, we have Meg, who's the general counsel at Dragos, which is an industrial cybersecurity company. And before that, she headed up the legal team at Shape Security, where she helped with their $1 billion acquisition by F5 Networks. Prior to that, she was associate general counsel at Mobile Iron. And before that, she worked at both Steptoe and Quinn Emanuel. And then to my left, we have Danielle Coleman, who is the senior director and associate general counsel at VMware. She oversees global commercial and IP litigation there, and manages a team of attorneys and paralegals and e-discovery project managers. Before that, she was the director of global litigation at Applied Materials, and was an IP litigation attorney at Morrison Foerster. I'll give you 3 guesses to where we met because I was at MoFo at the same time as her. And she also clerked for Judge Alsup. And then prior to law school, she actually worked at a pharmaceutical company doing biochemical research. So everyone here has a very impressive resume, but can you guys tell me a little bit about how your companies are involved in trade secrets or trade secret litigation, maybe starting with Emily?
Sure. So I'm on what we sort of call the overall litigation team for Google, but in particular for our purposes, our team handles sort of global patent litigation. So litigation filed anywhere in the world, and then US civil litigation. And that US civil litigation includes trade secret misappropriation cases. So we handle litigation matters, and then also we're involved in sort of pre-litigation counseling as needed on trade secret issues and other issues. And we've had a number of cases where we've been the defendant, a number of cases where we've been the plaintiff, perhaps most notably the Waymo Uber case that happened a few years ago.
I myself have been involved in a number of trade secret litigations. As outside counsel, I was an IP litigator for almost 10 years prior to going in-house. So I did handle those, and I think we're going to talk more about it later, but I saw the shift from a focus on patents to seeing a lot more trade secret litigation and making that change my own practice. In terms of what I have seen litigation-wise in my own in-house career, thankfully it has been none, but I have dealt with trade secret issues, I think, as every in-house, every general counsel does, particularly in the employment space, just trying to get ahead of them and also sort of juggling the issues of how to protect trade secrets without hampering innovation or preventing cooperation, coordination between teams.
Yes, so now in my current role, as Barbara mentioned, I do manage global litigation at VMware. That said, we haven't had as much trade secret litigation there, so my real involvement has been more in my previous roles, the law firm. For example, at MoFo, I worked on my first trade secret case actually with Barbara. And then also when I was in-house at Applied Materials, my job title was global litigation, IP protection. So we had a real big focus on protecting IP and just making sure we're keeping our trade secrets confidential. And that IP protection role has also carried over into my current role as well.
So before we get into the nitty-gritty of avoiding litigation and winning litigation, I did want to touch on a point that Megan made about the just explosion of trade secret cases. So since the DTSA was enacted in 2016, my practice, and I think generally, there's been a shift from patent protection to trade secret protection. Some of that may also be stemming from, AIA related issues and, Alice being used to invalidate patents. But some of it is just that you can now go to federal court with these trade secret actions. And so there's been, I think, a doubling of trade secret litigation cases since about 2016. And on top of that, you can get massive awards. So Yu-Ching, if you could put up slide 3, this just shows the various awards that have since basically all of them are 2022. I snuck the Motorola Hytera one in there because I was actually involved in that case. So that's from 2020, $764 million. But all of these other cases are from 2022. And we're talking, low end 7 million, high end 2 billion. Today, as we speak, there's a trial between Massimo and Apple where Massimo is seeking $3 billion. So thank you, Yu-Ching. So that's basically the landscape, is that we have more and more trade secret litigation and the stakes are incredibly high. At least that's what I'm seeing, but I'd like to get your impressions of, are you seeing trade secret litigation more and more at Google?
So I don't know that we're seeing more trade secret litigation as a whole. I will say, I sort of see it as two things. First, look, we're in a time of economic uncertainty in tech, in finance and other industries. Anytime you're in a period where employees are moving, there's increased risk of intentional or inadvertent misuse of information. So I certainly think in that period of time, you see more trade secret investigations, and you may see more trade secret litigation. The other thing is, as a litigator, I shouldn't say this is a good thing, but as a litigator in a time of an economic downturn, litigation increases. We saw it in 2008, 2009. I'd say the filings and the dockets in the last couple of years, particularly this year, suggest that there's an increase in IP litigation as a whole. What I think you may see more of, at least this is my personal belief, is you may see more cases that sort of aren't patent alone or aren't trade secret alone, but sort of have multiple IP issues in one case, and you sort of see the overlap of, is it a trade secret misappropriation? Is it willful infringement? Are there issues of copying for sort of secondary considerations of obviousness and patents? I mean, I think they all sort of, there is relationships, and I think you may see more of these mixed IP cases rather than pure patent cases.
Yeah, I'm definitely seeing that. Anyone else want to touch on what they're seeing? I know you said you haven't seen litigation.
I've seen threats, but what I've seen, especially in the startup space and then the tech company space, is up until the economy shifted, there was a lot of movement by employees. Now we're seeing employees getting laid off and seeking new jobs, and trade secret concerns are top of mind for employers as people move around. And you can't, with the feds coming out and saying they don't like non-competes and probably an end to non-competes. We are all sitting in California where non-competes are basically unenforceable. You have to look for other ways to protect yourself. And I anticipate that we'll see an uptick in employer cases against former employees who leave and take confidential info. And the risk, in the competitive landscape, the risk of the former employee or former employer suing the new employer and the former employee over trade secret issues when people move. And that's something we'll address on sort of best practices for dealing with your former employees, because it's always a risk, I think, either with malice or not, of people just taking things when they leave. And how important are those items?
I'm in agreement with Meg and Emily saying the same things related to on the litigation front. I think just maybe one thing I'll add to is just giving like the great resignation, employee mobility issues, and et cetera, and remote work policies that came into place, particularly during the pandemic, even more widespread than before, is I do see in tech companies that we're doing this kind of doubling down, looking at our IP protection protocols, how are we making sure that we're keeping confidential information in internal and not being exposed and et cetera. I know we'll talk about that a little bit more, but I think that was just also a renewed focus on those efforts to just double down to see about what do we need to do different with the changing landscape.
Are you seeing a shift in the type of protection that your company is seeking over a particular type of technology, whether it's choosing patents versus copyrights versus trade secrets, is that changing?
So I don't know that that's changing for us. I mean, we sort of look at it as the gating question is this going to be a trade secret, or is this going to be a patent or something else? You know, so we sort of take a holistic approach, right? You look at what is this technology and how am I going to use it? And really that's a business driven more than a legal driven, like how do we want to use this? Are we using it for internal testing? Is it going to be exposed to the public? Is it easy to reverse engineer it? Can you tell what's in there? Sort of, you know, you do all of that to figure out, are we going to apply for a trade secret? I mean, no, I'm sorry. I live in patent land. Are we going to try to keep this a trade secret? Or are we going to apply for a patent on it? And so that I think is where we start. And then we go from there with, yes, if we're going to keep it secret, you take one approach. And if not, if you're going to go the patent route, then you take another approach. And honestly, maybe it's a third approach. Maybe it's, you know, this is something that's better suited to open source, or, you know, sort of something like the Apache license where you do open source for your software, but you still have some IP protection. So in some ways, our decision making is the same. It's sort of sliding scale. But I agree. I think there is a bigger risk of things moving now, and so it's certainly something you're paying attention to.
And I want to get your thoughts, but I'm going to pause for a second and talk about provisional applications, because I know that this is something that Emily has something to say about. So I was at a conference before, and I got asked by some in-house counsel whether or not it's a good idea to file provisional applications on something that you might ultimately want to maintain trade secret protection over. And if you look at the case law, generally the courts think, okay, well, provisional applications are supposed to be confidential. So theoretically, you know, you're not revealing your trade secrets. But if you look at slide 4, I think it is, Yu Chang, that you'll see that there are definitely situations in which even provisional applications may be revealed under US law alone. So, you know, one is if the application is identified. And this slide will list, like, if there's the application number, serial number, filing date, you know, all of these things are identified in some other document, then that will make the actual provisional application public. Also, if you're claiming priority to it, that will make it public. And then there's this clause that frankly I didn't even know about before, where the office sua sponte can provide access if it's necessary to carry out an act of Congress or if warranted by other special circumstances. I'm unfortunately not going to be able to interpret that for you during this panel, but, you know, just wanted to keep that in mind. Thank you, Yu Chang, that it's, you know, just because it's provisional now doesn't mean that it will stay confidential. So Emily, what are your thoughts on that?
I mean, so first, I'm a paranoid person, right? So I assume if you put it in writing, it's going to go public at some point, and hopefully not on the front of the New York Times, but sometimes that happens. But that combined with the fact that, look, you may be filing in the US, and that's one thing, but you may be filing in other jurisdictions. They have different publication rules. You know, it just, I would assume if it's in an application in any way, it is going to go public. And honestly, I don't even know how much this would come up in the real world, because again, going back to, you make a decision, at least we would early on, is this a trade secret or is this a patent? So you've already sort of made that decision and gone down a path once you file a patent application. But man, I'd be really cautious putting something in an application that I wanted to keep secret.
What about Meg?
I absolutely agree. And you know, when we're considering patenting versus trade secret protection, then it's sometimes you can have it both ways to a certain degree, where your patent is covering the processes and then how you're doing it. And your trade secret is how you implement those, you know, the source code, the technology, and the underlying know-how your company holds. But you do have to be careful, because if you want your patents to be enforceable and good, then they need to be more detailed. And everybody is I think, fighting that fight. In the startup space, I'm saying, you know, there is, historically in good times, people have lots of money and they want to spend the money. And then there's the, let's get lots of patents and they'll show we're a big hit company. And then the new startups file lots of patents, and it turns out they're all garbage. You know, you can get a patent, but that doesn't mean it's an enforceable patent. So it's a nice little feather in your cap, but it may not be useful down the line unless you've really got a sophisticated IP lawyer, probably in-house and as your prosecutor. So what I'm seeing now, I think, is a pullback away from that, because patents cost money, and you really want to justify the spend. Whether you're a Google or you're a startup, but particularly at startups like you, smaller companies, you really want to justify the spend. So patenting really key pieces of your tech, or what you are changing in the space you are in makes sense, but you don't want to just be out there patenting everything. But then trade secret becomes more important because you do want a way to protect what you're doing in the market. And it's a push-pull, like you want to look in your market of like, are my competitors suddenly filing a lot of patents? Well, crud, I probably should too, because there's things that I'm never going to assert against them, but I don't want to be in a position where I can't do that.
What about VMware or your experiences?
Yeah, I think my experience at companies, overall, it's about best return on investment, risk tolerance, but more practically too, just looking at things like the time period, right? On trade secret, you can basically have it protected indefinitely where a patent expires, or taking a look like, is this the kind of thing that we actually can keep secret or not? Can it be independently developed or easily reverse engineered? Also, some of the concerns we mentioned before about, the patent landscape has changed with Alice and patent eligibility. Maybe it has to be covered by trade secret because there's some concern that they'll be patentable. So I think there's pros and cons of both and just weighing some of those practical things. Yeah. All right. Covered most of the things.
Well, you're all in agreement.
Yeah.
Yes. Well, so you talked about the secrecy measure. So I let me take a step back. I think it goes without saying that in order to have a trade secret, you need to keep that stuff secret. And that's one of the things you need to establish if you're going to actually file a trade secret litigation. But actually, these reasonable measures to maintain secrecy, which is what the standard is in litigation, that, as everyone I think touched on, is actually super important to avoid litigation in the first place, so that your secrets don't accidentally walk away. So I wanted to talk about that for a minute. And one thing I would mention is that the Sedona conference is a great reference for kind of practical tips on what to do to maintain secrecy, to identify trade secrets, etc. And they have a specific edition that is, what's appropriate for different size companies to do to maintain secrecy, because even courts will recognize that a large company may take different, steps than a smaller company. So on that front, maybe Emily and Danielle can talk about what large companies should be doing to maintain secrecy. And then Meg, if you want to touch on the smaller companies.
Damn, you go first. So I'm going to agree with everything.
Feel like disagree. I help you disagree with this. So yeah, I think for large companies or for any size companies, one thing is confidentiality agreements, having those with your employees, but also with any third parties that you're working with, talking about non-disclosure, how to maintain confidential information, marking documents confidential or trade secret.
Do you actually have a trade secret label that
we do not use trade? I have not seen, let's put it this way, the trade secret labeling, but we do use at this company, other companies, even when it's law firm, confidentiality labels, right? And some of that is spelled out. And
it's not on every single document. You actually use it for things that are confidential.
Well, that's the idea.
You should not attorney-client privilege, right?
Anything that's public, confidential, but I'm sure there are some things that probably skate by that. So but maybe to another point, one thing to do important is training, right? Training the employees about those different categories of confidential information, the marking confidential, and why it's actually important. So I find that's important to explain the practical implications of not doing certain things or doing them. Also limiting just access. I've worked in different environments and represented companies in different environments. And I've seen different levels of access. Some companies where they have anyone can sort of access source code or really confidential documents, whereas others just varying levels of access depending on your job function, if you sort of need to know or need to have access. But that's definitely one thing to think about, is just limiting the access so it's not all that sensitive information is just exposed to everyone when it doesn't have to be. And even basic things like limiting physical access, which I think is pretty standard, or badges to get into certain locations or different other ID methods. Another thing that I've seen used in different varying degrees are those technical controls. or just monitoring like downloads or uploads. If there's certain large volumes of that happening, to sort of flag that for the relevant department so that can be looked into in case, sometimes there's innocent explanation and sometimes not.
Have you actually seen that play out where there's a bunch of documents being downloaded and it was for various purposes?
Yes, I guess.
Oh, yeah.
Indeed, we've gotten notice from IT about monitoring about, hey, check on this sort of thing.
Oh, wow.
Yeah.
Yeah, I mean, I think that the document, just monitoring documents through technological means is very helpful. And I frankly, I seem to be former employee at one of my companies who downloaded a lot of documents and then had a good chat with me about that. But IT just called and was like, hey, like, this is unusual. And the unusual downloads or uploads were reviewed by the security team and then escalated to legal. And they came straight to me where it was, what is going on? And sometimes security would just call the person and be like, what are you doing? And there was an explanation. So anytime, say like during due diligence on another funding round, I would proactively tell the security team, these people are working on due diligence. So they're going to download, we're going to download 2,000 customer contracts and then upload them into an external system. This is what we're doing today. So don't have a heart attack. But you'd rather get called about something like that, be like, no, it's fine, but not be aware of it. So I hammer that home like it all the time. Like technical controls are much better than contractual controls. I think that's the case, whether it's with your employees, whether it's with your partners, whether it's with your customers. If they can't do something nefarious, then there's the risk isn't there. The risk is significantly lowered to force them to take additional actions and try to get around the technology that's preventing access. And again, it's not always possible, but I try to, that's advice I give to early startups is always build access controls into your products and into your systems so that you can, or at minimum logging. So you can see who has been working on this, who's been accessing this, and be like, hey, like maybe the marketing guy didn't need to be in our source code repository. Like, and it's just it is easier to track that way.
So I agree with things both of you have said, like in terms of, it's absolutely in terms of confidentiality of information, I think it's labeling and controlling access. I mean, I think that's absolutely like, and do we have levels of confidentiality? Like, is that a thing that makes sense? Like something is confidential, but something is highly confidential, or something is need to know, and is access controlled technologically to make that happen? The flip side of it is something you mentioned earlier, is too much control can sometimes stifle innovation. And as an in-house lawyer, it is your role to make sure that you're not, control is good, control is important, but there's a difference between the true trade secret information and the things that are, yes, they're company confidential, but look, yeah, if they went public, it wouldn't be the end of the world. And so there is merit in having access to things as a, even as a large company, so that people can collaborate and can come up with new ideas. And so there's a tension. Like I don't think there's a particular, like 100% best way to do it. I think there's sort of, you have to figure out where your comfort is, and again, how important something is and how important isn't it. I mean, the other thing, look about it, especially in a large company, is you have the benefit of a benefit from a legal perspective, maybe not from the employee, from the engineering perspective, the benefit of a large legal team, right? So you have like product counsel, who I sort of always think of as the GC of the product, and they're the sort of front line. If I need to talk to a lawyer, I know who to go to, and that comes in through your training. It just comes in through, this is the person that I can ask questions to, and they're accessible, and they keep up on sort of making sure we're following best practices and procedures. And so, you've got those folks who are sort of front line, and then you've got your security legal team that is investigating when you have, say, 10,000 downloads, and maybe you have to bring a trade secret action because that's not right. And then, you have sort of your litigation, or, whomever, or your patents or IP or whomever, who are providing sort of, counseling and get brought in. So I think it's making sure that your employees have the training to know, hey, I'm gonna have a question, I'm gonna go to legal. and I know who to go to, and like, then that sort of kicks off discussions with whoever needs to be involved to prevent trade misappropriation either way, either your own or misappropriation of somebody else's.
So we talked about the technical measures, and you just touched on employees. So can you tell me a little bit about what your companies do, or what companies should consider doing when employees are coming in from a different company to make sure they're not bringing anything with them? Like, do you have some sort of, official procedure where you sit down and like explain to them what they're allowed to do, what they're not allowed to do, anything to prevent them from uploading materials, any of that?
I see more and more just employment agreements specifically addressing that just say, here are your confidentiality obligations to us as a new employee. But part of that is, we don't want anything from your prior employer. You are not to rely on it. You're not to bring it. It's spelled out there in the contract. Are people reading their entire employment contract? Depends. But then it becomes the issue of education and telling people like, you can't do that, and then just keeping an eye on it. My company loves Slack. I think a lot of companies love Slack and other messaging. So just keeping an eye on like what's being shared, and like, hey, where did that come from? Right? So like, okay, it's on the internet. The answer should be the internet. It should not be anything else. But and educating people, and again, just reminding people, like, often things are done with good intention, not bad intention, but that doesn't mean it's the right thing to do. So educating employees, senior employees know better. Like, they're not going to download a bunch of stuff, bring it in as a general matter. But I think junior employees who are like really young, who would be helpful, can share information, and that it's developing a culture of respect for third-party confidential information. Educating people, making sure that you're continuously repeating the messaging on the importance of protecting our trade secrets and respecting other people's.
So do you guys have trainings like on a regular basis on trade secrets specifically, or is it more just like
I think it's rolled into other trainings? There's so many training, like there's privacy training, there's security training, and there's IT training, and it's touched upon. But I think that's helpful. Like, it's helpful for the types of messaging, whether it's like data privacy or it's trade secret or it's security, to have touch points and reminders within other training places. So again, like, you repeat the message again and again, and people understand that they need to be respectful of that.
Yeah, I agree we have it across the board, and confidentiality, employment agreements, confidentiality provisions about not only, the respect for our company's information, but the company that you're coming from. Don't bring that information in, open our systems, very specific about that kind of thing. But having that training to help reinforce that onboarding, that, in case you don't read the agreement, it's good, and that continual training. And I've also seen like awareness campaigns be effective, where you're talking about having a culture of compliance to really, spread the message, make sure it's staying top of mind, and sort of what we were talking about before, just embedding that along throughout the process about access and expectations of our employees as well.
And what about for employees that are leaving? Like, do you have an exit interview process that includes, wipe all your systems, personal devices, yada yada? What do you do there?
I think one thing you definitely want to think about is are you going to have an exit interview? Are you going to have sort of a certificate of clean, like, departure, if you will? And that's things like getting back your managed devices, which I think, to Danielle, to your point earlier, in a remote work environment, that can take a little more time and take a little more follow-up to make sure, like, no, seriously, did we get your laptop back? Did you FedEx it back? I think it's a combination of having security manage the devices, not allowing access to confidential information on a personal device unless it's managed, getting those things wiped or returned back to you as part of the exit interview, reminding people of their obligations. Because again, a lot of times it's inadvertent, right? Like, someone will take a laptop with them because they just forget they have it. Or you'll download, and this, especially with more junior people, I'm going to download copies of my work because I might need them for an interview. And it's like, and they just don't understand, like, maybe you can't do that. And so I do think there's some, that if you go through sort of the exit interview process and you have procedures, it allows people to understand that maybe they're doing things they didn't mean to do, but they are nonetheless things you would prefer they not do. And then look, and then sometimes it comes back to the exfil investigations afterwards and finding out what suddenly someone did in the last couple of weeks right before they left. So I think it is helpful to have a process in place for, all right, if this happens, what do we do?
So have you learned anything from those situations where you found out 2 weeks later that you could have changed the exit interview process in any way to prevent?
I certainly think that we're paying a lot of attention. I think we pay more. I think we always paid attention, but I think perhaps we pay more attention.
One thing for the exit interview that's helpful too is just try to assess risk. Of course,
Yeah.
not everyone's going to admit right away, but just are they going to a top competitor?
Yeah.
Which Jackson, what level of access to that employee have as far as exposure to trade secret or confidential information? And also using that exit interview or termination certificates as a way to educate them again about like, these are the policies, these are what you are bound by. And talking to them about getting their devices returned. Another thing that I've seen used sparingly, but occasionally is if depending on if they're going to a competitor or there is some concern, sending them an exit letter. And as well as maybe even going so far as to send an exit letter to their next employer, not necessarily accusing of anything, but just reminding of obligations and that sort of thing.
Well, and balancing that, I mean, because you'll see, generally, in having these discussions of like how long you keep someone's laptop in case something is fishy once they're gone, and you're like, okay, generally within 90 days you're gonna know. So like you can set policies of like, please don't wipe someone's laptop the day they leave. Like that is not helpful. Maybe do it 30 days out, do it 90 days out, whatever it is, but like tag it, hold it, wipe it on a schedule. That is very helpful. And as Danielle was saying, like the letters to people, just reminding them of obligations when you find out where they've gone. And then weighing the like, how big of a risk is this person? We know the person, like if we think they're a risk, like, do I send the letter? I mean, that's polite, so that's a reminder. Like, CC their employer, do you like have your outside employment counsel send a letter that says, hey, it looks like you might have done some things, so we are writing a letter to you and writing a letter directly to your new employer. You don't want to do that every time. I get those from time to time. I'm like, this is foolish. This person is not. But if you have suspicions, then it's worth sticking the flag in the ground of them.
So talking about employees moving around, I think Meg, you actually touched on the FTC proposed ban on non-competes, which for those of you who have not heard about this, it's not just no non-competes going forward, but it would be rescinding existing non-competes. And it could also apply to NDAs that could be construed as non-competes. So what impact, if any, do you guys anticipate if this ban actually goes into effect, which by the way is anticipated this year? So if it does, they'll make a decision this year.
I mean, just speaking for myself, I think non-competes are horribly abused. So I am not sorry to see them go. I think it has hit a point where there's been so much abuse of non-competes. And I don't like point at the tech world in particular. I'm thinking about non-competes for like contract security guards in the Midwest, like you have to sign a non-compete.
And doctors.
Doctors, nurses, people who work in fast food restaurants. I mean, it's insane like where this has gone. From a technical perspective, I think it's a big wake-up call for all of us who are working in tech companies, because the land of, we'll just sign these, it's broad, like we'll only enforce it against like this set of people and only in these instances. You're like, cool, how about we only have those people sign it and we lay out those instances? And it's a heavy lift for HR to have to track like who gets a non-compete, what's the scope of the non-compete, how much are we going to define that? Like you can't just have the California offer letter that goes out to every employee there. I think it becomes more burdensome, but I view it as a good thing because it will require all of us to evaluate like who really is going to have access and what do we care about? Like how much does it matter? Like how much does it matter if this person leaves versus that? How much do they know and how much do you think the competitor knows anyway? But it's more work. It's more work and I think will cause some. It's going to cause a lot of headaches and a lot of work and a lot of pain in the short term, but I don't view it as a bad thing. Employees are going to move around and you have to recognize.
Yeah.
I don't know that I have a lot to add. I mean, look, I'm not an employment lawyer, I'm an IP lawyer, so I look at the world from I look at the world from an IP perspective, and it's like California didn't have non-compete. And I mean, yes, okay, in theory, but in practice. So in 47 states do. And so how the FTC sort of proposal comes out is implemented as drafted. Are there any changes made? I mean, I do think it's going to change the world. How much? I don't know yet. We'll see what it looks like when they file, if and when.
Yeah, I mean, like Emily mentioned, in California is already an issue with non-competes and some other states as well. So I think, it's just taking a look at the protection measures, making sure we have those in place, looking at freshly at the non-disclosure agreements, which I understand may possibly affect some of those, making sure they're limited in scope, things like that. But time will tell.
Okay, well, then switching gears a little bit to winning litigation. So let's assume all of these measures failed miserably. What do you do to get the $1 billion verdict if you're on the plaintiff side, or to avoid that if you're on the defense side? And I don't have a straight answer for you, but there are, I think, two things that I've seen come up in cases that I think are super important. One is defining your trade secrets early. And that's something that in California is actually required, and more courts are requiring early disclosure and clear disclosure, so that it's sufficient particularity for you to understand the difference between the trade secret and things that are generally known or that you could readily ascertain. And you might not even be able to get past the complaint stage. You can actually file a motion to dismiss if there isn't sufficient identification of your trade secrets in your complaint. Now, just as an aside, obviously don't put your trade secrets into a public filing. You might want to put those under seal, just given the reasonable measures requirement. So that's one thing. And then the other thing is just how you're defining your trade secrets, the scope of them, because it's, as a plaintiff, if you're defining them too narrowly, then you might not capture what the defendant took. But if you're capturing or you're defining them too broadly, then you're essentially setting yourself up to have to prove more, right? Because the courts are saying that if, for example, if you have a compilation, the ITC recently said that you actually have to show that everything in the compilation was used. And so if you're making your trade secret, and by the way, it's not binding authority for most of us, but if that type of authority and that type of issue is out there. So if you make your trade secret super broad, then you're going to have a hard time showing that every element of it, or sufficient elements of it, substantial elements of it were used. And then another thing I'll put out there is that courts don't love it if you're changing your definitions throughout the litigation. So I actually saw a case where the plaintiff won, but then wasn't able to get attorney's fees that they otherwise might have, because they kept changing what their trade secrets were, the scope of them, how many there were, and all of that. And the court was like, well, that made the litigation super inefficient, and kept moving the target. So it's, again, early definition and good definition, I guess, are the two things I would say. But what about you guys? What, if you've seen litigation, what lessons have you learned from that? How do you win if you're a plaintiff? How do you not lose if you're a defendant? Winning. Yeah.
Well, so I'll take the defendant side. Obviously, we've had both. Our plaintiff side is perhaps more well known than our defendant side, but we've done both. And so I think one key lesson, especially as in-house counsel, if you get a cease and desist letter, you deal with it quickly. At least that's my perspective. And you need to conduct a thorough investigation as soon as possible. And I say that because it is very hard to prove a negative. it was very hard to prove you didn't misuse someone's confidential information. You can do it, but it is not an easy thing to do. And so you want to find out as quickly as possible, is there confidential information that came into our company that we didn't want? Because you don't want it, right? That's the fundamental. Like, you come from a place of, we don't want this, we want to build our own. We don't want to take what somebody else did. But figuring out, where is that, did it come in? Where is it? Can we, limit how far that has gone quickly? So taking those things seriously. And the flip side is, look, sometimes you get, sort of circling back, sometimes you get cease and desist letters because people are not happy that employees have left and gone to a competitor. And so, so you really have to investigate early, is there something here? Or is it, is it the beginning of an employment litigation rather than really a true trade secret litigation? And look, we've had that happen. We've had, like, I can think of one example we had a few years ago where we had a salesperson talk to somebody as a favor, and the salesperson promptly forgot about it. And then we were accused of trade secret misappropriation for video technology. Did the salesperson work on video technology? No. Was they involved in any way? No. And we have the luxury of being able to litigate and ultimately win that because we could show, look, he had no relationship with our, with our video tech. The engineers had never heard of this company. We did independent development. That is key. As a defendant, you have to be able to show your independent development, because you have to be able to explain to whoever the fact finder is, this is our process. It had nothing to do with it. But again, it's not easy to prove a negative.
But I echo Emily's comment to do not sit on letters. Like, you have to go in there, and then the documentation of these, these investigations that result out of the letters matters, because it demonstrates a seriousness, a continuing seriousness regarding other people's trade secrets or respect for technology. So you can say, like, every time I get one of these letters, we have a phone call with the person, we look into it. If there are allegations within the letters, more than you hired somebody and they work for me, so they must have taken our stuff. If there's any allegation in there that is presenting facts or alleged facts, then you have to look into it. And you look into it and you document, you looked into it, and you run the search, you ask people. And it's not, I think, as with all employment matters, it's not necessarily that you're like churning the ocean and like searching every system and talking to 400 people. Like, an investigation can be one phone call, you write it down and say, I got this letter, this is fine, I don't need to respond, or you respond to the letter with it, yeah, we got it. Like, we have training and education, and we're going to track that. But taking it seriously to demonstrate how that you take it seriously is important.
So is that approach different than you would take for a patent infringement claim, like a demand letter on the patent side?
I feel like a lot of patent infringement claims, like, putting aside willfulness, it's purely you're using this, right? Like, you don't have to have intent unless you're making a willfulness claim. And often the letters we get are not claiming willfulness. That letter's going to then be the basis of the willfulness claim later. So I do think it's somewhat different in that I think patent investigation is more focused on, it's less focused on the individuals and more focused on the system. And I think the trade secret investigation, at least initially, is starting with the individual.
Yeah, I think the same for us. For the patent investigation, it's a little bit different tone. To the extent we're looking at our internal systems, our internal products, it's more about would these be prior art or things like that. And focus more on, investigating that something came in. Because a lot of times the first time we get any notice the existence of those patents are from a letter or a lawsuit.
Typically. Okay, so you guys have talked to me about what do you do if you're actually the defendant? What about if you might be the plaintiff? Any tips there, lessons learned?
I mean, I think you have to move quickly, right? Because the biggest, at least from my perspective, what you're trying to get out of as a plaintiff, a trade secret litigation, is not, yeah, sure, like restitution is nice, but that's not my focus. My focus isn't restitution. My focus is I got to stop this because this is a fundamental threat to the business. And that is, if we are filing a trade secret matter, I think it's because we think this is serious and we need to deal with it. It's not accidental. It's not gray area. It is, something has gone wrong. Someone has taken 10,000 files and, turns out has an agreement to cover them if they are sued for intellectual property issues. So in that circumstance, I think you can't sit on it. You have to move quickly. You have to get your ducks in a row quickly. To your point, you have to figure out how you're going to find your trade secrets early. It is not the type of litigation where you're going to come back in a year or two because you need the action to stop. And that's really what your focus is more than anything, I think, is how do I get this to stop?
So I'm going to digress for 1 second and
Okay.
talk about the ITC. So as I'm sure you all know, people file patent infringement claims in the ITC all the time, but you can also bring trade secret claims in the ITC. The numbers are minuscule relative to patent claims. Do you have any idea like why that is? Is that something that you might consider, given that your goal is to stop the misappropriation? Because the obvious downside of the ITC is you can't get damages.
Right. It's an interesting question as to why more people aren't, and I'm not sure I know the answer. I will say to the extent you're trying to move quickly, the ITC is clearly somewhere that will move quickly for you. So it's interesting. I'm not really sure. I haven't seen much in the ITC. In terms of trade secret, I don't necessarily know why people aren't going there unless they're just unless it's just depending on sort of what the technology is an issue and whether it's, whether it would benefit from an importation ban, but it's interesting and I'm not sure why.
Are there other mechanisms that you guys bring into play to protect trade secrets, like breach of contract claims? And how effective do you think those are relative to an actual trade secret misappropriation claim?
Yeah, so in my practice, I have seen the use of breach of contract or unfair competition or other claims like that being used. One example might be with third parties, where we have our agreements where we have restrictions on use in there that we can point to and things like that. And maybe starting off with a letter to them about it first before going to a lawsuit. But in those contracts, of course, we're making sure that we had that limited use, that they're supposed to keep it confidential. Usually we try to include some audit rights, depending on which things like that, and non-transfer or non-assignability provisions. So we've seen that be effective where sometimes it's not even going to a lawsuit, but some of the companies I work with, we can send letters for reciting those things or using our rights to do an audit. For example, we have a reason to believe there's been some breach of contract or some misuse of our confidential information.
Yeah, and then you don't actually have to prove that it was used, right? You were talking about the independent development being a defense to trade secret misappropriation, whereas the breach of contract claim, you can literally just be like, well, you downloaded this. So there,
The damages are, I think, damages on the confidentiality without the trade secret. It's a challenge. I think the damages with trade secret and with use are more clear cut and you're going to see bigger damages, but that doesn't mean that you can't get in front of a jury and be like, it's trade. And maybe the jury's like, I don't know, is it really a trade secret? But it really seems to have hurt you and you have a contract. So maybe I'll give you a bigger contract, award than I would have without the sort of trade secret presentation hanging over even if trade secret isn't found.
yes, and that's exactly what happened. There's the Versada Ford case that had both trade secret and contract claims, and that may have been why they got the award that they did. Which, by the way, the bigger part of the award was breach of contract,
Right.
But the theme of trade secret misappropriation, I'm sure helped with that. All right, well, I hear we have a ton of questions. So Yu-Ching, you want to read us some? And
there are a lot of wonderful questions, and I'm afraid we may not be able to get to all of them, but here's one to get started. Do you have specific procedures for employees to even be able to identify and disclose trade secrets they create, as opposed to protecting existing trade secrets so they can be tracked and protected?
disclosure, but trade secret disclosure situation.
I'm not aware of that, but I did read in the Sedona conference materials that TSMC, it's public, they do catalog. They have over like 140,000 trade secrets they cataloged for their company. So.
And that's a question I got a lot as outside counsel is like, should we catalog our trade secrets? And my response was always, are you going to keep it up to date? Whose responsibility is it? Because once you catalog, if you then don't update your catalog, all of the development you've done from the day you made the catalog forever, it's really hard to prove that's a trade secret because the plaintiff is going to, or the defendant is going to be like, you have a list, this isn't on the list. So generally it's better not to have a list, in my opinion, because I don't see companies keeping their list current. And it's hard. It's hard to say what exactly is a trade secret. I don't know. It's something you recognize. You know it when you see it, but it's a challenge.
And I wonder as a litigator, how much that would impact you when you went into trial and suddenly you're trying to say, here's the trade secret that's appropriated, and you've never defined them as such because it following whatever system you would have followed. And so, yeah, I mean, it's not a great fact.
Rules are lovely if you and policies if you follow them, and they are really problematic in litigation if you don't.
You have to be consistent.
Yes, you have to be consistent.
All right, Yu Chang, next
There-
one.
There is actually a comment from the audience that there are also about negative trade secrets that are nearly impossible to catalog, even if we want to. Here's another question that's possibly a hot button topic. Posting confidential information onto ChatGPT. Do you see a prosecution of employees for doing so willfully?
That is a giant headache. That is a very active discussion in every general counsel group that I'm in right now on like, what do you do about this? And for my company, I'm like, don't put anything remotely confidential into these systems. Like, just don't do it, because yes, you still own that, but the system learns off it, so the system has it. And the system's going to spit information about that out to other people, and then how do you say that you have a trade secret or even that it's confidential?
Are you seeing source code being put in, or is it like actual documents, or?
Oh, I have heard of all kinds of stuff being put in. I mean, Samsung had a breach the other week that tracked back to somebody putting information in ChatGPT.
I read about the Samsung issue too.
Yeah, Samsung caught it themselves, but it was something that got disclosed as in the news. You do not want that. Like, that is not at all what you want. So drawing bright lines. That said, interesting technology, I think, has a lot of use. So the use limitations and instructions and policies are going to have to evolve, because it is too valuable and too useful to not be taking advantage of that. But you got to take advantage with a knowledge of the risk to your confidential
And
information.
I'm sure our company, as well as others, thinking about training and guidelines that need to be
Yeah.
updated.
Yeah.
But you should make sure
Yeah.
consistently capturing these kind of activities.
I mean, we have a working group right now. It's like, oh, we have to update this. Like, we have given general instructions out to the company, but like the working group is like sort of chasing the train as it's driving. We're like, okay, we're building this, we're flying, we're building.
And by the way, Debevoise has a data security task force and a chat GPT task force. So if anyone has any questions, let me know.
Okay.
Flood for the firm here. Next question.
This question asked about, are there any trade secret considerations in the life science / biotech industry that may be different from the tech industry?
I was on a panel with the
I was a long time ago, but I was thinking about it from the other side. I'm trying to remember. And it's like 20 years ago.
There is a lot more complication on the joint ventures within biotech, and who owns what tech, who owns what pieces of the IP. And the advice, particularly when there's partnerships, is to make sure that prior to beginning the partnership, who owns what each party is bringing in, and what the intent on ownership is going out, is incredibly important. And within those partnerships, you're going to be trading or sharing some trade secrets. So understanding, again, like, do you have strong confidentiality controls, and what is the intent of what is going to be produced coming out of here, and how much of each side's IP is going to be pulled into that on the ownership side. I don't know that it's different from technology side inherently, but I think in practice it is much different, and that's why it's very important to have biotech people working on your biotech.
Yeah, and I think one distinction is just the way that technology is captured in the industry. So in the tech world, you have your source code, and you might have, diagrams and other things that are like very concrete, and you can say, however many lines of code or however many documents were downloaded. Whereas in the biotech world, it's to a certain extent, it's just like, I'm simplifying here, but one idea, right? And that idea, obviously, I'm sure there's some recording of it, but it's not like you need to download an entire source code repository to capture that. And so that makes it in some ways, more of a problem in the biotech world, because you're not documenting things in the same way.
This last question relates to, I guess, winning the trade secret litigation. Any thoughts on seeking injunctions early as plaintiff?
I mean, I would say in any litigation, I would want to seek an injunction as soon as possible, if for no other reason the fact that failure to seek one early may make it harder for you to get one later. But I mean, obviously, the other thing is, as Emily said, you probably want to stop them as soon as possible. So yes, all for early injunctions and maybe even TROs, given depending on the circumstances.
Yeah, I've seen with the serious trade secret misappropriation of for current or former employee running off with the proverbial laptop full of your secrets, and maybe buying a plane ticket out of it. Then you have to act very fast. Like, you want a TRO, you want law enforcement involved, you want to pull out all the stops to do it as quickly as you can, as Emily said. But even in a situation of like a competitor having trade secret information, you want to act quickly, because as if I am a defendant on the other side, I'm gonna be like, you sent me a letter 6 months ago and I didn't respond. It's like, or I wrote back, nah, and then 6 months later, you're like, I'm gonna file a lawsuit. And like, yeah, like, go ahead. I'm gonna get that dismissed because you didn't do anything. If you didn't take it seriously, the court isn't gonna take it seriously, and you're not gonna demonstrate damages. The jury's just not gonna take you seriously if you send a letter and fall in the hole, and then you're like, well, I really don't like Barbara, so I'm gonna sue her 6 months later. Yeah. I do like Barbara. I want to.
I like Barbara.
Well, we're at 10:30, guys, so I really appreciate everyone logging in, and again to ChIPs for letting us host this, and to my close friends and colleagues. Thank you for joining the panel.
Thank you for having us.
Thank you.